All right, ladies and gentlemen, welcome to the show. Let's go ahead and get rolling. It's 11:02 here on a Wednesday morning. Thank you for joining us and welcome to today's webinar. My name is Anthony James, a member of CREB, a broker and moderator for today's webinar. This event, of course, is being presented and sponsored by the California Real Estate Brokers, Inc., which is a 50% owner of MetroList. If you're unfamiliar with CREB, I'll just take a quick minute to give you a background of what CREB is and what we do. So CREB actually offers a unified broker voice in the MetroList multiple listing service. We provide brokers and agents with educational opportunities and cooperative matters, such as what we're talking about today, which of course is all forms related. We're going to get into that and introduce our panelists and guests here in just a moment. But part of CREB's mission is to empower our broker members and their agents with timely and relevant educational information on important real estate topics. And I think we would all agree there's a very big, important topic out there that we've been navigating for months now, years, quite frankly, if we go back all the way to the beginning of this. But we're going to get into these forms changes that just released a couple of weeks ago. And today's topic is really going to focus on those new forms, specifically the buyer representation and broker compensation agreement, and all the other great related forms that were released back on July 24th. Today's webinar is going to focus on just those forms. We've brought in some experts here to help us navigate all of the changes and the new forms that have been added. And this webinar, just so you know, is being recorded, and a link to the video will be made available after today's session. So let me give you just a quick overview of how we're going to navigate our time together this morning. We had over 2,700 folks register for today's seminar. For optimal viewing, if you'd like, we'd recommend you setting your Zoom webinar settings under the viewing drop-down menu to speaker and hide non-video participants. We do have a number of folks that are on that are not on video, so if you hide that, it'll focus in and allow the viewing experience to be a little bit more improved there for you. The review of the new C.A.R. real estate forms, this is going to take us about 45 minutes or so. We've activated the Q&A in the webinar, and you'll be able to ask questions. And I assure you, we will do our very best to answer as many questions as possible. If we see multiple questions on the same topic, we will answer them at the end of today's presentation. Please note that we're unable to, of course, address individual questions about personal situations. We are posting an antitrust statement that has been added in the chat for your reference. The webinar is scheduled to end right around 12:15, and we have a lot of information to get through, so we're going to get rolling here in just a moment. If you have follow-up questions, of course, after today's webinar, you can reach out to your broker, or you can, of course, always call the C.A.R. legal hotline. Our panelists will be providing some helpful resources, and that C.A.R. legal hotline phone number and a variety of other resources in the chat section as well. All right, let's welcome our panelists. And our presenter first, Jana Gardner. Are you on, Jana? Let's see your face there. There you are. Good morning. How are you? Oh, there it is, the mute.
Good morning. I'm great. Happy to be here.
Gets you every time. All right. Welcome to the show here. For those of you that have maybe not seen Jana before, Jana Gardner is senior counsel with the California the California Association of REALTORS. And she is one of the few subject matter experts on the new forms that C.A.R. recently released. She's been advising members on the legal hotline, presenting legal updates, teaching classes on disclosures, the RPA, the RLA, legal Q&As. You do a lot for C.A.R., right, Jana?
I try to, yeah.
So Jana is going to be our presenter, walking us through all of the new form changes and the new related forms, as well as part of the NAR settlement that, of course, we are all navigating together. We also have a couple other panelists here. Let's get Corey Gold and Alvina Safar on, if we would. Good morning. Good to see you. We've also invited these two folks here to join us because both of them actually sit on the C.A.R. Standard Forms Committee, also experts in the subject matter that we're discussing today. So first up, I've got Corey Gold. He's the broker owner of Next Home Cornerstone Real Estate in the great city of Davis, a CREB member, and also a member of, like I mentioned, the C.A.R. Standard Forms Committee. Good morning, Corey.
Good morning, everyone. Looking forward to today.
All right, and also joining us is Alvina Safar, broker owner of Cal Prime Realty in Modesto, again, also a CREB member and a member of the C.A.R. Standard Forms Committee. Good morning, Alvina.
Good morning, everyone. Looking forward to tackling those questions today.
All right, both Corey and Alvina, they are going to help us navigate the questions. Again, those Q&A feature inside of Zoom is activated. You can post your questions there for Jana as she's walking through today's presentation. And then we're going to have Corey and Alvina, myself, kind of navigate those questions to the best of our ability and answer everything towards the end of today's session. All right, Jana, are you ready to get started?
I'm ready.
Okay, I'm going to pass it over to you, Jana Gardner, C.A.R. Senior Counsel, to walk us through these new forms changes. Go ahead, Jana, the stage is yours.
Thank you. All right, everyone, it's great to be here with you today. Glad to have this opportunity to walk through these forms changes with you. Like Anthony was saying, this is a huge transition period for the industry. And we want to make sure you have a really good understanding of these forms, that C.A.R. is prepared to help you navigate this new sort of way of doing business, new way forward, compliance with the NAR settlement provisions and all of that. So just briefly, even though we have 45 minutes or so to talk about the forms today, I could talk about them for 4 hours, right? So we're going to make sure to post some resources for you. I'm going to go over the most significant changes you need to know, the most significant forms that have been revised, really focusing on the listing agreement and the buyer representation agreement. But there's addenda, there's more than a dozen forms that were updated or released in this July forms release. And so we'll make sure to be posting in the chat where you can go and we have free classes available. We have FAQs, we have other recorded presentations. So we'll make sure all of that information gets shared with you. But with my time today, I do want to make sure that we hit the most important forms. And so let's go ahead and get started doing that. You can see my screen, Anthony?
I sure can, yep.
All right, excellent. So you'll see we're starting with the listing agreement because there's a whole host of rule changes that are required by the NAR settlement provisions, right? But at the end of the day, there's really two significant changes that you want to make sure you're ready for, which is one, no more offers of cooperating compensation in the MLS, and mandatory written buyer representation agreements for buyers agents who are working with buyers before showing them property. So, the compensation structure and the written buyer representation agreement, those are really the two biggest areas that you're going to want to familiarize yourself with and get comfortable with. Really, now's the time. These changes are going into effect across MLSs essentially next week, with the latest deadline being August 17th. But my understanding is your local MLS, as well as many others, are going to be doing so earlier in the week next week. So now's the time to get familiar and comfortable. And of course, these forms are already out. We wanted to make sure the forms were available for you prior to these changes, so nobody was caught, sort of looking with forms that weren't going to help them out to be in compliance. So let's start with the listing agreement. I'm sure you see it obviously looks a little bit different than it used to. It looks more like the purchase agreement now, have that grid in there. And this is all about helping this information be more digestible to the consumer. We got such great feedback from the grid structure in the purchase agreement that we have this in the listing agreement now as well too. And so what that means for you is all of the negotiable terms are in this grid. So hopefully it's going to be very straightforward to sit down with a client, walk them through it, and everything that is negotiable, modifiable is in this one place. That includes the listing period, the listing price, and the type of property, if it's manufactured home or probate, that's noted here. The one thing I do want to highlight in listing period, this change came about earlier this year, but it's going to come up again later. We talk about buyer representation, which there is a maximum listing period length, right? So a listing is not to exceed 24 months for a residential 1 to 4 unit property. That's from a law that was passed. That's required by law. So that's why we have that in there. But 24 months, decent period of time. There's going to be a shorter time period for buyer rep. We'll talk about that in a little bit. But let's talk about compensation. This is really sort of what we're here to discuss today, and what I really want to make sure everyone walks away from today with a thorough understanding, which is how compensation is now structured under the listing agreement. You'll see in the bold section here where we start in 2C that we have this statutory notice, right? Where we remind everybody that the amount of real estate commissions is not fixed. It's completely negotiable, set by each broker individually to be negotiated with their own client. Now, that advisory has been in our forms for a very long time. It's been required by California law for a very long time. And so it's also now a provision of the NAR settlement, which we were already doing, but you'll see now we have this reference C attached broker compensation advisory, BCA form. We're going to look at that form next because it goes into a lot more detail about how compensation works. So we say right up top, of course, it's not fixed. It's fully negotiable between each broker and their client. But when we look at the BCA form, you'll see even more explanation. But let's look at the compensation structure. So starting 2C1, here is essentially the listing compensation. Compensation to seller's broker for seller side of transaction only. So what you're probably used to, right, from the old way the listings were all set up, was the seller was agreeing to compensate their listing broker a certain amount, and then the listing broker was being authorized to go out and advertise that he would share that with the buyer's broker. Typically that was done through the MLS. That is what has changed. The seller's broker side compensation and the buyer's broker side compensation are now totally split. So in this form, you'll see there is no place to talk about the buyer's broker being paid. Why? Because the buyer's broker isn't a party to this agreement. This is a contract between the seller and the listing broker, and the seller is agreeing how much they're going to compensate their listing broker. We'll talk about how buyer's broker compensation gets determined and paid. Of course, we'll spend a lot of time on that as well. But really, when you're looking at the listing agreement, the way you think about it now is this is a contract between the listing broker and their seller client. And the seller client is agreeing to pay their own broker a certain amount for conducting the transaction. And so that's what goes there. 2C1, fairly straightforward. Now, 2C2 is a bit of a wrinkle. This is kind of a new concept, so I want to spend a little bit of time talking about it. We're still talking about compensation to the seller's broker. This is an optional section where if the parties want, they can agree for an additional compensation amount to be paid to the seller's broker if the buyer is unrepresented. So not if there's a dual agency. If there's a dual agency, the buyer's represented by the seller's broker. They're going to have a buyer rep agreement. That's going to be handled just like any other transaction where both sides have representation. This is here for the potential scenario where a buyer approaches a listing agent and says, I don't want representation. I don't want to sign a buyer rep agreement. I don't want to work with an agent. I want to do this deal myself. Now, that's always been a possibility. You've maybe encountered that in your transactions in the past. I know I've been getting calls on it about that scenario on the hotline for years. So it's not a brand new scenario. It's just there's maybe the possibility now, because buyer's agency is going to be so much more formalized, that there may be more buyers who feel like, I don't want to commit to that. I can do this myself. And how that plays out could go a number of ways. If they're a very experienced investor who's done hundreds of transactions, if they're an attorney or a real estate attorney, or they have access to one, could be smooth sailing. But it could be someone who maybe is a little bit more confident in their ability to do the transaction than maybe is warranted. Obviously, C.A.R.'s belief, and I think everybody on this call's belief, is that that person would absolutely benefit from buyer side representation, but you can't force it on them, right? So all that being said, if there's a scenario where the buyer says, I want to submit this offer, I want to buy this property, but I don't want representation, the seller is still allowed to consider that offer and accept that offer if that's something they want to do. But the reality of the situation is if you're the listing broker, that's going to make your job and your life a lot harder, right? Because you're not representing the buyer's side. So you're not advising them or helping them in the traditional sense, but practically speaking, it's probably just going to be more legwork for you. Making the property available. They don't have their own agents to come and make the property available, open for them for, due diligence, inspections, appraisals, making sure, sort of tracking things down, working with escrow, making sure they're getting what they need because there's just no other agent on the buyer side. So all of that being said, the seller might agree to the agent and say, okay, here's what I'm going to agree to pay you in sort of what we would consider a standard transaction. But if there's an unrepresented buyer, I know that's a lot more work for you. So I'm going to agree to pay you this additional amount. Totally optional. Like I said, totally optional section. Seller can just say, no, I'm paying you what I'm paying you no matter how the deal works. But that's something the parties can negotiate for. And just before I move on, if you do find yourself in that situation with an unrepresented buyer, there's two important things to remember. One is we have a form called the BNA, the Buyer Non-Agency Agreement, that's really vital that you use, which it basically puts in writing and says to the buyer, you're choosing to proceed unrepresented. You have the right to an agent or other representation. You're choosing to forego that. I represent the seller only. Every time I interact with you, it's in furtherance of the seller's best interests. And as the seller's agent, I am not your agent. So even if I, for example, send you a form to fill out, which is something that can be done, you know, can't send out blank C.A.R. forms just to any old person, but if the buyer wants to fill out an offer or otherwise, you know, they want to fill out a request for repair or something like that, you could put the property information, parties information, and then give it to the buyer and say, you know, here you go, do your best. And that's essentially how that would have to be handled. But it also just reminds them that even to the extent you are doing something like that or answering a logistical question for them, you're not their agent. And also, what I keep reminding people is it's equally as important to walk the walk as it is to talk the talk. Essentially, what I mean is give them a buyer non-agency form, but then live up to it, right? You can't just put in writing, I'm not advising you. You have to actually not advise them. And frankly, every time you communicate with them, you want to be reminding them, I'm not your agent, seek advice elsewhere, you know, and just protect yourself and all the parties in the transaction if you find yourself dealing with that scenario. All right, a couple more things on compensation here in 2C3 and 4. These are not new concepts, but I will say I've been getting a lot of questions about them because I think anytime we have a significant forms change, people maybe read the contract a little bit closer than they have in the past. And so they maybe pick up on things that they had skimmed over previously. So this section here in 2C3, continuation of right to compensation, it's a concept that's been in the form for as long as I've been at C.A.R., but we just finally gave it a name. Some people have called this the sunset period or protection period. It's basically where you can ask for a certain window of time after your listing expires, where if any of the buyers who submitted offers or were shown the property during your listing period, if they come back, you're still entitled to compensation. It's to try to prevent a scenario from someone waiting until, let's say, you have a 6-month listing on day 6 month and 1, waiting for somebody and then, you know, trying to cut you out of the deal. Provides a little cushion, a little protection so that people hopefully don't engage in that kind of behavior. To that extent, we also have a place to note if the seller was previously listed with somebody else and they have a protection period and protected buyers, then there's a place to note that to protect everybody so the seller doesn't end up obligated to pay 2 commissions. All right, and then since I talked about compensation, I want to move over briefly to that BCA form I mentioned earlier, the Broker Compensation Advisory. This is a form that is attached to both the listing agreement and the buyer representation agreement. And it's the same form for both. So what you'll notice is it explains how sellers brokers are compensated and how buyers brokers are compensated. And that we want sellers to have that information and buyers to have that information. So there's complete understanding between the parties about how compensation is structured and how it works in their transaction. And so it lays out in writing, essentially, hopefully the conversations you're already having when you sit down with your clients to talk about these issues. So it talks about some of the concepts we already discussed, which is, of course, compensation is negotiable. What happens in that unrepresented buyer situation? This kind of explains what I was talking about how that might impact the transaction, references using the buyer non-agency form so that everybody understands what the relationships are. And then we do also talk about the possibility of dual agency. Dual agency, of course, is and remains legal in California. So there's a possibility that the buyer may want to be represented by the listing agent. Both sides have to agree and consent to that. And it's going to be documented, again, the way the listing agreement and the buyer rep agreement are always documented. It's nothing different for a dual agent. It's just one agent or office doing that documentation on both sides. All right, and then the second part here talks about the broker's compensation by buyers. So we talked about the listing side. This also talks about the buyer side, talks about compensation being fully negotiable, talks about the new requirement for written agreement. So one of the advantages of this BCA form is a tool for you to sort of assist you with these conversations you're having with your clients, because you may have clients who this is not their first transaction, they're repeat sellers, they're repeat buyers, and they may be asking, this is different than now. This isn't how it worked last time we did a deal. Why is it different now? And so one of the uses of this form is to help you explain that to them. And so we have a section here explaining why, if you're a buyer, you're being told you have to sign a written representation agreement pursuant to these rules that are introduced by the NAR settlement. And some proposed pretty soon it's going to be a legal requirement in the state of California as well. And talks about the advantages of having a written agreement, clarity, transparency, understanding, all of that. And then part 3 is where we're going to talk about the different ways a buyer's agent can end up getting paid. That's probably the number one question that understandably everybody is asking, is saying, well, if there's no offer of compensation in the MLS, there's nowhere in the listing agreement that talks about how, the buyer's agent is getting paid. Well, then how are they getting paid? And obviously that's what we're here to talk about today. But this section really sums it up here in the BCA form, in the broker compensation advisory. And it basically says there's really two main, but 3 potential scenarios for how the buyer's agent is going to get paid in the transaction. The first one being they have a buyer representation agreement. So just like the seller has a listing agreement and they agree to pay their listing agent, buyer has a buyer representation agreement. They could simply pay their own agent pursuant to the terms of their contract. Is that going to be feasible for every buyer out there? Probably not, but there are buyers who can and will be willing to do that, and even ones who've done it in the past, even though it's been a little bit less common. Now, the second option here is probably going to be maybe the more, if not most, here it is, this option here, the more, if not most common scenario you're going to encounter, which is the buyer can utilize the purchase agreement to ask the seller to pay buyer side compensation. So at the end of the day, it may financially end up working out the same way it has in the past, where the seller ultimately, out of their proceeds, is agreeing to make sure the brokers get compensated. But instead of it just being, the seller and the listing broker, and then the agents take it from there, it really is now this process that involves all of the principals and the parties to the transaction. Sellers agree to pay their agent, buyers agree to pay their agent, but buyer can use the purchase agreement and say, hey, seller, I would like you, out of your proceeds, to pay my agent. And that payment would offset any obligation of the buyer under the buyer rep agreement, where they said they're going to pay their agent. If the agent's paid by the seller, that will offset or maybe take care of what would otherwise be the buyer's obligation to make that payment. And so you might have noticed we've had this in the purchase agreement for some time. 3G3 in the RPA is a checkbox where the buyer can say, seller, I want you to pay compensation. And then the SPBB form, seller payment to buyer's broker, is where the seller can say, okay, yes, I'll do that. The number one question I get is, well, can the seller counter that? Sure, they can. They can counter anything, right? They could counter and say, well, maybe I want a higher price so that my net works out, or maybe they want to counter the SPBB specifically and say, well, you're asking for X amount, but I'm only willing to pay Y amount instead. And then that will at least reduce the obligation the buyer has to pay any commission. The other question I get is, can a buyer's agent agree to reduce their compensation if the seller comes back and says, I'm only going to pay a portion? Buyer's agent's not obligated to do that. They're entitled to the full amount under their agreement. But of course, it's negotiable, and they can always decide if they are willing or able to make any accommodations to make a deal work. That will be negotiated on a case-by-case basis. And then finally, if there is an unrepresented seller, we talked about unrepresented buyers, but we've always known about unrepresented sellers, right? FSBOs, for sale by owners. In that case, the buyer's agent could approach that seller directly with what's called a single party compensation agreement and a seller non-agency agreement to say, I represent this buyer who wants to purchase your property. Would you be willing to compensate me for doing this deal and representing the buyer only, and document it that way? And then final point on here, we do have a note down here in C, basically explaining sort of the history, again, to help you with clients who say, why are we talking about all this? Didn't it used to be different? And then we have a section here to sort of explain, yes, that was the historical method of doing things. This is the current and future way of doing things, and help provide that necessary context. All right, I'm going to mention one more concept on the listing agreement. I don't know if there's anything that Anthony thinks I need to address before we start talking about concessions next.
Let's see here. I think you can keep rolling. Just go
Okay.
ahead and elaborate a little bit more if you'd like, and then I'll sort through these questions for you.
All right, yeah, no, go ahead. Just wanted to make sure there was nobody screaming for my attention. But I do have one more concept I want to discuss on the listing agreement before we move on and start talking about sort of some other important forms to get familiar with. But one of those is right here. No, sorry, my screen got weird. Bear with me one second here. Okay, there we go. All right, so the last thing I want to discuss on the listing agreement is reference to the MLS and MLS terms. So down here in 2E, it defaults to saying that the property is, of course, going to be marketed on the MLS, and it'll be disclosed which MLS that is. And then we have a reference to an attached and incorporated form in the agreement, which is the new MLSA, the MLS addendum. So you might remember that the listing agreement previously had, about a page worth of paragraphs and information about the MLS and its importance and use. Also completely valid, but just because of the new structure with the grid and sort of for clarity's sake, all of that MLS language was moved to this attachment, the MLSA. And so let's take a quick look at that. It's right at the very end of the listing agreement, so past the signatures. Then we have the MLS addendum. So it talks about, again, these portions you're probably familiar with. So what is the MLS, public marketing, how does it work, opting out if that's something the seller wants to do. But really what's new and important to be aware of here is paragraph 5. So you may have heard that part of the NAR settlement, which specified that there could not be offers of commission or compensation in the MLS, it did draw a distinction and say, however, an MLS can have potentially a field where the seller indicates their willingness to consider making concessions to the buyer. So that's what it's talking about here in 5A. And it's really doing two things. It's explaining what we mean by concession. So, you're probably familiar with this, right? Buyers have always been able to ask either in the offer or during the escrow period for credits, towards closing costs in lieu of repairs, things like that. Those are seller concessions where the seller says, sure, out of my proceeds at closing, I'm going to credit that amount back to the buyer, and the buyer can apply it in whichever way they and their lender agree is workable for them. So that's basically what it explains in here. It mentions things like escrow, title, lender fees, repairs, inspections. But of course, we have a new cost that concessions could be applied to, right? Which is buyer broker compensation. So, keep in mind, concessions is not another word for compensation. It's a completely different concept. It's saying, hey, buyer, this money is going to you. You have a certain number of financial obligations, money you have to bring in to close the deal. You can take concessions and apply it however you want for any of these things. Now, why we have this all in here, because the seller's always been allowed to and able to, negotiate concessions. But per the settlement, NAR specifies that MLSs can have a field where the seller specifically indicates yes or no. Is the seller willing or not willing to consider offers that contain concessions? And you probably heard how different that is from the way compensation fields used to work. That was just saying, here's a promise to pay a certain amount. That's not what the concession field is. The concession field is saying, seller will consider offers where buyer is asking for concessions, or no, seller will not consider offers where the buyer is asking for concessions. So I will say the default in here is that the seller is not authorizing the broker to put in the MLS that seller is willing to consider offers asking for concessions. Why is that the default? Well, two reasons. One, just because you don't advertise it specifically, of course, the seller can still always consider it. So it's just a matter of whether it's being advertised or not. The seller might say, I don't want to put that out there. I want to just tell people to make their offers and I'll consider them as they come in. Totally fine. Also, why it defaults to no is not every single MLS is going to have this field. Many are. Some may even have a field where people can write in additional information or amounts or things, but I think that's not going to be super common. But some, maybe many MLSs will have a field that just is a yes or no about seller's willingness. And so the seller might say, yeah, I want to encourage buyers, even if buyers are nervous because they're going to be asking me to pay their agent's compensation, I'm open to that. So I'm going to go ahead and have you advertise that I'm open to making concessions, considering offers with concessions, and the buyers can submit those. And so if the seller wants to do that, check the box here in the MLS addendum to the RLA. So now that's part of the listing agreement, and the seller, or the listing broker, excuse me, has the authorization to make that advertisement in the MLS. All right. So let me now go to one more form that's really on the seller's side here, which is the open house visitor non-agency disclosure and sign-in. I know this is very zoomed out. I'll zoom in on a second. I just wanted to show you visually that this is just a one-page form, because I've gotten many questions. One of the other most common questions we're getting is, how does this impact open houses? Does this mean I have to stand at the front door of an open house and have everybody who walks through the door sign a representation agreement before I can show them the property? The answer to that is no. The requirement under the settlement for buyer representation agreements is that any agent who is, quote, working with a buyer must have them sign a written agreement prior to showing them the property. But NAR has clarified that a listing agent or a listing broker is not automatically working with a buyer just because they are holding the house open or making the property available for that buyer to tour it. Again, it comes back to that sort of unrepresented buyer concept, which is listing agent can say, I represent the seller only. I'm not your agent. I'm not advising you. We're not having confidential communications. But, if you want representation, we can talk about that. And that's what this form is doing. So what we have here in this OHNASI, the open house sign-in sheet, is basically a sign-in sheet, as it says, that basically lays out what I was just saying. The listing agent does not represent the buyer, prospective buyer, I should say, just because they're touring the property. To the extent they're communicating, it's still in furtherance of representation of the seller. It's not confidential communication. But again, if the visitor wants to write an offer or the visitor wants to be represented, now you can sit down and talk to them about the options for buyer representation that we're going to look at. Main question I've been getting on this form is it mandatory? It's not mandatory. It's highly recommended. I know a lot of agents traditionally have used sign-in sheets anyway. So this is just a suggestion to say, it lets you have your sign-in sheet and it provides some very helpful and protective disclaimers, because just with now the formalization of buyer agency relationships, you don't want a scenario where after someone comes through an open house, if something strange happens down the line and they say, oh, well, you showed me the property, so I thought that meant you were my agent. It would be helpful to say, no, remember, I gave you that form, you looked at it, you signed it where it said I'm not your agent. Always helpful to have. Do you have to have a buyer sign this when they come to the property? You don't. Again, recommended, but when you're holding an open house, you're not a bouncer, right? You're not there to stand at the door and kick people out. You're there to let people see the property. I would just be extra careful. If someone says, no, I'm not signing that, then I would just give them a lot of space. Really try not to answer any questions from that for them. Give them if you have a flyer or something like that, a printout, let them walk around. And then if they want to come talk to you about the property in more detail, maybe now that's when you say, okay, you want to have some further discussions. I'd like you to sign my sign-in sheet, or if you want to talk buyer representation, I have some other forms that we could discuss as well. So that's the idea behind the open house non-agency form. All right.
Jana, but before you move on, you can just go back to the listing agreement and
Yes,
that
of course.
There's a couple of questions that I think we can attack before we move on here.
Okay. Go back up to the top of the listing agreement here. Sorry, there we go. All right, here we go. Yep. Got it.
All right, there it is. Okay. A couple of questions specifically about C1, see attached compensation schedule.
Sure.
Asking, is there a compensation schedule form? What might that look like? Any additional information or elaboration you can give on what that might be?
Great question. Thank you for asking that. This is another good example of language that was in the previous listing agreement, but I think maybe just didn't get looked at. And hey, that's one of the advantages to the new structure of the form, is it's making people, see these things more clearly. It's not as buried in lengthy paragraphs and things like that. So working backwards, it's not a standard form. There's not a C.A.R. form called compensation schedule. Because really what this is, and always has been, is an option for parties to negotiate more nuance in how a broker's compensation is structured. So it's, the way it's set up now, the parties are agreeing that the seller will pay the broker either a certain dollar amount or a certain percentage of the purchase price of the property, right? Just sort of no matter what else happens, that's what they're agreeing to. But they could want something more complicated than that. They could want to say, I'll pay you this amount if it closes by this date, otherwise this. I'll pay you this amount if we get a purchase price over this, otherwise this. The parties could have some kind of more complicated, structure. It doesn't have to be as straightforward as just, I'll pay you this amount. So that's always been an option. And like I said, it's not a standard form. You would just really just attach like a piece of paper that says compensation schedule, and here's the additional terms we want to agree to based on whatever the seller's asking for. I don't think especially based on the number of questions I've been getting, I do not think this is a super common practice, but it's just an option that's there if the seller and the broker want to have a more complicated compensation structure than the straightforward one that the agreement currently calls for.
So just so we're clear, that is not the area to check a box and then put in what the buyer's compensation is to be.
That is correct. It is not for that. That is not, and I've been getting that question a lot, but no, this is really just saying, again, everything in C1, everything in this listing agreement we're not talking any compensation going to the buyer's side. We're just saying, what is the seller going to compensate their listing broker? And that's what we're doing in C1, and that's what the compensation schedule would be elaborating on as well.
I've seen this one a couple of times, specifically under C1. It says percentage of list price. Folks are asking, why isn't that the agreed upon purchase price versus the word list price?
Great question. So you'll probably notice it says percentage of the listing price, and then down below it says percentage above is based on purchase price if buyer and seller sign a purchase agreement. So the reason why we base it on the list price is for essentially kind of boring legal reasons, which is in order to have a binding agreement, you have to have sort of definable material terms. And so one of those has to be, what is the compensation that's going to be paid? And so you don't want to be defining the compensation based on an amount you don't know yet. Because, and here's the sort of, I guess, unfortunate reason for that is what happens if there's a breach of the contract. So I think, obviously, like I said, we specify that amount will be adjusted to be based on the purchase price if a purchase agreement is signed. But unfortunately, sometimes a purchase agreement isn't signed. Sometimes sellers breach the listing contract. Sometimes they just cancel it. They pull it off the market. They try to go to another agent, whatever their behavior is. Sometimes the seller breaches the contract, and that entitles the listing broker to their compensation. That is their damages based on their breach of the listing agreement. And if it was just based on the purchase price, you wouldn't be able to calculate it. So there has to be a way for the listing broker to say, hey, client, you breached the agreement, you owe me X amount, which per the agreement would be the percentage of the listing price. And then, hopefully the vast majority of the time, everyone behaves, everyone honors the contract, everyone's happy when a deal closes, and the final amount is going to be based on the actual purchase price. We do specify that. We just have to have that based on the listing price there on the off chance that there's a dispute.
C3 under the continuation period, is there any recommended period there, or it's just, again, a negotiable item, right?
Negotiable item governed by reasonableness. I wouldn't put some sort of like 10-year period in there. I think you'll notice that it's based on calendar days, right? So I think putting that, we're kind of encouraging people to keep it onto a maybe shorter, more reasonable time period that could be counted in days as opposed to, months or years. But I mean, people use things like 30, 60, 90, 120, whatever it is. It's all just based on negotiation. And, I wouldn't put thousands of days in there, but I think most people can figure out a reasonable term that works for them.
And then kind of a follow-up to that question, there is a clause somewhere, I believe, where you have to submit the names, right?
Yes.
Prospective buyers within a certain amount of time. So can you highlight very quickly?
Absolutely. Great point. Thank you for highlighting that. So, like I said, everything here in the grid is we're just talking about those negotiable amounts or days, lengths, things like that. But there's obviously a lot more context about each of these provisions. You want to know where to go for more context, look at this paragraph here. And this says, okay, 4D2, that's where we talk about this concept. So we go down to 4D2, continuation for broker procured buyers. So yeah, really important thing to remember. I talk to too many people on the hotline who miss this step and end up giving up some pretty important rights. So in order to have these rights over these, what we call procured or protected buyers, you have to, one, fill in a certain number of days up there in 2C, and then you have to keep a list, provide a list of buyers who physically entered and were shown the property during the listing period or who submitted offers during that time period. And then this is the key, broker's right to compensation pursuant to that paragraph shall apply only if prior to expiration of the agreement or any extension, broker delivers that list to buyer. So basically, if your listing's set to expire in the next couple days and it doesn't look like it's going to be renewed or extended, get that list to your client. If the expiration date comes and goes and 5 days later you send them the list, it's too late. And now you've lost your protection for those prospective buyers. Years ago, you used to have a small window after expiration, but that was changed many years ago now. And it's just cleaner to say, look, you know when it's expiring. So prior to the expiration, get that list to your client. And that's the way to make sure you actually have protection if any of those buyers come back.
Yep. Okay. And then the last question, I'll let you move on. I know we want to get to the buyer representation agreement here. If you could just scroll back up, there was one more paragraph in the grid specific under the compensation.
Got it.
There you go. Under C4,
Yes.
seller's obligation to pay previous brokers. Questions very specifically are, what does that mean? Like, what are we talking about here?
So it follows on what we just talked about, right? So let's sort of go step by step. So let's say you have a listing, it's expiring, 15 people either toured the property or submitted offers. The day before expiration, you give that list to your seller client. They have the list. You have a protection period of however many days. It expires, they're going to move on. Now they're going to go to listing broker number 2. And now they're filling out this form with listing broker number 2, and they're going to get to this section. And it's going to say, okay, is there a previous listing broker? Oh, there is. They're going to put down the name of broker number 1. Is there any compensation that's owed to that broker if the property is transferred to certain buyers whose names are put on the list? There is. Then those listed buyers basically are being carved out of the agreement, because what we don't want is a situation where the seller is obligating themselves to pay to brokers. So if they have a list of buyers and it says for the next X number of days, I have to go and pay my first agent if we sell to any of these buyers, then this section is saying that, well, what it's saying here is, here's the buyers for whom I would owe compensation to a previous agent. And then when you go down to 4F, 4F makes it clear that if there is another broker who was previously involved, and if the seller ends up selling to one of those protected buyers during that continuation period, then basically this the listing agreement, it doesn't apply to that particular transaction, because the seller doesn't want to be obligated to pay 2 people, and broker number 2 doesn't want to work for free if they have to pay broker number 1. So basically it's like, okay, if those people come back, you got to go back to the previous broker and do that deal, so that you don't end up owing people multiple compensations, or you don't ask anyone to work for free.
Right. Okay. And then just a final note, if we could just reiterate, because I'm seeing we're creative, this, group of realtors and brokers, right? Like, can I use a modification of terms or attach an addendum or see attached compensation schedule to clearly highlight that the seller is willing to pay broker compensation of whatever, XYZ, right? The answer is no, you can't. And if you can just reaffirm that and tie it back to the NAR settlement terms.
Yeah, here's what I'll say. I will say that, one, like you said, brokers are creative. Can the C.A.R. forms be modified? I mean, it's possible. You just have to do it very intentionally and very carefully. For a wide variety of reasons, the C.A.R. forms are not set up to support or facilitate, sellers offering, paying the listing broker to then offer cooperating compensation to a buyer's broker. The hope, the expectation is that you explain to your seller, hey, today you're agreeing to pay me. If you are open to paying the buyer's broker, that's great. That's probably going to widen our pool of buyers, but we can get offers from the buyer, see what they ask for, and that can be negotiated on a case-by-case basis. Like, that's how it's set up to work. If people want to have a different arrangement, certain other arrangements may be permissible under the NAR settlement, but if you're an agent, you would need to talk to your broker about your broker's comfortability with modifying C.A.R. contracts. And if you are a broker, or once you're working with your broker, you're probably going to have to consult your own attorney and outside counsel to make sure you're drafting language that is NAR settlement compliant, legally compliant. Like you said, people get really creative, and I've seen some very creative drafting done by realtors and brokers. But if you want to explore alternative structures or things that are different or beyond what the C.A.R. standard forms call for, make sure you are doing it on the advice of your own personal legal counsel and being as cautious as possible.
Perfect. All right, moving on. Buyer representation agreement. Thank you.
All right, let's move over to the buyer representation agreement. Give me 1 second here. Okay. There we went. Okay. So yeah, buyer representation agreement. This form we have had for a while. We've always had buyer representations agreement. Some of you may have been familiar with or even used the old BRE, buyer representation exclusive. We've had the BRBC for a while, but it has now also been restructured in light of the settlement and trying to make it absolutely as crystal clear to all the parties involved as to how it works and how compensation and everything is structured. There's a few and this is another time where I'll say, I could go line by line over this form for the next hour. We all are very busy. We don't have that kind of time today, but I will once again suggest or recommend we have a free course through C.A.R. and through our education department that is a nearly 90-minute long course that is on the buyer representation agreement and the addenda to it. It's free to all C.A.R. members. So I would recommend, I think we'll post a link for you in the chat. So if you do want to go and sort of dig into this line by line, I think that's a great resource that's available to you. But I want to today highlight the major concepts of it. So at least you have a familiarity or a working knowledge if you haven't really gotten to dig into it yet. So really two major points to take away right away, which is you will notice that this defaults to being a non-exclusive agreement. So unlike the listing agreement, which is an exclusive authorization to sell, represent the seller, this defaults to a non-exclusive right. Now it can become exclusive by checking the box here in A2 and then going and initialing the paragraph on page 15. We'll look at that in 1 second. But basically, we wanted to make sure, or C.A.R. and everybody who was making decisions on the forms wanted to make sure that the parties had a wide variety of options for what kind of representation to enter into, and that, we don't want this form to be too intimidating to buyers, right? This is a brand new concept for most people. Many, if not, I think the vast majority of buyers, this is going to be the first time they're going to be asked to sign a buyer representation agreement and saying, hey, sit down and sign this contract to work with me exclusively for the next period of time. It's just not a concept that a ton of consumers and even frankly, most agents are really sort of comfortable with yet or used to doing. So especially on the buyer side, buyers have always had a little bit more flexibility to pop around on their own. Has that had its own headaches and problems? It absolutely has. And that's one of the advantages to having buyer representation agreements. So people actually understand the nature of their relationship, what entitles someone to compensation, and what the rights and obligations of both client and agent are in the transaction. So there's really two things in this form that are designed to, help facilitate talking to a buyer and explaining the benefits of signing this form without it seeming too intimidating. One is that it defaults to being non-exclusive, and we'll talk about how and when you're entitled to compensation in a non-exclusive agreement. And the other one is the representation period. So remember how on the listing agreement, 24 months was the max listing representation period? It's much shorter for buyer representation. It's a maximum of a 3-month representation period. Why? One, again, little bit less intimidating, a little bit, saying, hey, I'm not asking you to sign up to work with me for a year here, just for 3 months. Let's work together. Let's see how it goes. If we have a great working relationship, but you just haven't got an offer accepted, it can be renewed and extended for 3 months at a time to continue working together. So it's not 3 months and you're out, but it's also, let's start, and this is the time period that we're going to commit to have this relationship. The other key reason why it's 3 months is you might have heard me mention earlier that the buyer representation agreements are going to be required by the terms of the NAR settlement starting next week. Well, it looks like they're going to be required by law starting January 1st, 2025. There's a bill that's already sort of flown through the legislature and is expected to be signed by the governor, which is going to make having a buyer representation agreement a legal requirement for California licensees, not just an NAR settlement requirement. And that law sets the maximum representation period at 3 months. So not a lot of point in having a listing or a representation period longer than that, when in 4.5 months by law, that's going to be the maximum anyway. Just makes logical sense to have that set up now. All right, so like I was saying, non-exclusive versus exclusive. The really difference between exclusive and non-exclusive is, well, on an exclusive representation agreement, the part of the buyer is saying, if I purchase any property at all that fits the definition of this agreement over our representation period, and let's just say it's 3 months since that's the max, if over the next 3 months I purchase any, let's say, single family residential property, in a certain county in Sacramento or wherever you may be located, then you're going to be my agent and you're entitled to that compensation. That's how exclusivity works. And so that's why, in order to have an exclusive agreement, you got to check the box here, and you have to go down to the last page, to paragraph 15, with this box, exclusive representation. This is where it explains that this is an exclusive agreement and that the broker is devoting time and resources to helping the buyer find and acquire their property, right? So it's not just, it's basically saying, from the minute we start working together, I'm working for you. Even when we're not together, I'm helping you. I'm devoting my time, my energy, my money, my resources to helping you find the right property. And so it's only reasonable that, I'm committing to you, you commit to me. And for this time period, even if you go out and you find your own property, you're going to contact me and we're going to work together on that property. And so compensation is owed if any property is purchased. And then we'll talk about cancellation in a second. So buyer has to initial here to say they really understand what exclusivity means. The difference for non-exclusive is, as you see here, there's a reference to paragraph 4B. So let's go there. 4B talks about broker's right to compensation in a non-exclusive agreement, which requires broker involvement. So basically this is saying we have a non-exclusive agreement. Theoretically, you could go out and find a property that I never knew about or touched. Another agent could show it to you. You could show it, find it yourself. I'm not entitled to compensation in that situation. But for any property where the buyer was shown the property by the broker, either physically or virtually, or an offer was submitted, or a market analysis was done, or there was an introduction of the property from the buyer's broker to the buyer, then we have broker involvement, and that's what entitles that broker to compensation on any of those properties during the representation period. So that's really the difference, right? Is there's a broker involvement analysis for a non-exclusive relationship versus, hey, you buy anything in our area that we described for the next window of time, and I'm entitled to compensation. So I already mentioned you can indicate single family or property type. It defaults to single family residence, but you can indicate different types of property, of course. You want to have some location in there. If the buyer changes their mind and goes and buys out of state or something, that's not really something you're going to be able to help them with. And you want to be even more specific than California. You want to really describe the actual market area where the buyer is looking. The more specific the terms of the agreement, the better it holds up, the more enforceable it is. So you want to have that information in there. And then I want to mention here in paragraph 2C that we have an option for the buyer to add more information about what they're looking for. So more than just a single family residence in Sacramento, they may want to say a 3-bedroom with a backyard, single story, with a pool, without a pool. They might have additional, what we're calling preferences and priorities. And we have a form. I know a lot of agents, again, they sit down, they have these conversations with their clients already. That's great. We just now have a form where you can attach it to this agreement and actually walk through with your client. Now, the number one question I've got is, well, does that narrow my rights? Does that mean now I'm only entitled to compensation if they buy a, single story house that doesn't have a pool and has 3 bedrooms? No, you'll notice the property to be acquired is just here in B. C is a separate section. It's just to help guide the relationship and, get information from your client. That's all it is. It does not mean, as long as they meet the criteria that's laid out here in 2B, then compensation is owed. Property is excluded from representation. Again, just like there's a continuation period for the listing agreement, there's a continuation period for the buyer rep agreement. So it could be that if they had previously been working with a buyer's agent and there are a list of broker involved properties that another agent has rights to for a window of time, gonna want to carve those out so the buyer doesn't end up owing compensation to multiple people. And then compensation section here. So again, we have the same notice, the same reference to the BCA form to go talk to your clients about how compensation is structured and works, talk through that form with them just like we looked at. And then amount of compensation. There's a place to put percentage of the acquisition price or a certain amount. And I'll just go ahead and answer the number one question, which is you have to have an amount in here. And it has to be the amount that you are planning, hoping, and entitled to get compensated for representing the buyer. The terms of the NAR settlement say 2 things. They say, 1, the amount of compensation to be paid to the buyer's agent has to be specified as an ascertainable amount in the representation agreement. So it cannot be a vague, whatever we get the seller to pay me, or up to a certain amount, or between a certain amount. It has to be an ascertainable specific amount, either a percentage of the acquisition price or a flat fee. And the other thing that the NAR settlement says is a buyer's broker cannot earn from any source an amount that exceeds what's called for in the buyer representation agreement. So previously, people who've worked with buyer rep agreements in the past, it was possible, and I think a lot of people did this, to put a small amount in here, to put some sort of nominal or low amount, and then say, well, there might be a higher offer of compensation on the MLS, or I might be able to get the other side to compensate me more. That previously was allowed. That is not permissible under the NAR settlement. The maximum a buyer's agent can be paid is the amount called for in this agreement. And, I mentioned earlier about the way the buyer's agent gets paid, the main one being the buyer using the RPA to ask for the buyer side compensation. The seller has the right to say, I want to see how much your agent is entitled to be paid under the compensation agreement, under the buyer, let's say the BRBC, this form. And so basically the seller can say, look, I know they're only allowed to earn what that BRBC calls for. And so again, back down to that last page, this last page can be used. There's a reason we have this confirmation of compensation section here, because this last page can be provided to a seller to say, yeah, my agreement calls for me to be paid that certain amount. And then the seller can say, okay, great, then I agree to pay that certain amount or chip in towards it or whatever the seller ends up agreeing to. But so, long story, not particularly short, you have to have an amount of compensation in there that is the amount that you plan to be paid for, representing the buyer on this transaction. Talk to a lot of agents, a lot of brokers, it's really going to be about sitting down with buyer clients, discussing your value proposition, the value you bring to representing them in a transaction, and what the compensation is and what you're earning it for. And that's kind of the point of having all of this in here. So that is buyer side compensation. Again, talked about how if I mentioned this in the use of the RPA, but this makes it really clear. So this is what you can show to a buyer who's maybe a little bit nervous, sitting down saying, so I'm agreeing to pay you X%, compensation on top of what I'm paying for the property. yes, that is what they're agreeing to, but if the broker receives compensation from seller or any other source for broker's representation, that's credited against buyer's obligation to pay. So buyer's promising you to pay X amount, you use the seller payment to buyer's broker with the purchase agreement, and seller agrees to pay X amount, buyer's not coming out of pocket for anything. Their obligation is covered. That's sort of the idea, the structure of how this is hopefully typically going to play out for consumers. Continuation period works just like it does in the listing agreement prior to the expiration of the agreement, or if there's a cancellation, you might have a little bit wiggle room on the timing. You give a list of what's called broker involved properties, and we have a form, notice of broker involved properties, where the broker can say, hey, here's the properties I showed you or we submitted offers on. And if during my continuation period, you come back and decide to buy any of those properties, I'm entitled to compensation for those specifically identified properties. Cancellation rights for a non-exclusive agreement, it can be canceled at any time. Either side, broker or agent, can say this isn't working out, let's walk away, let's cancel. Cancellation effective immediately. An exclusive agreement, there's a 30-day cancellation window. So you can basically have a 30-day notice that, hey, our agreement's going to come to an end 30 days from now, even in an exclusive agreement. So again, providing buyers a lot of peace of mind that if they're not happy with the situation they're in, they're not handcuffed, they're not sort of stuck, they have cancellation rights, they have more flexibility than they might have been worried about. All right, and then final thing I want to note here, and then I have one more form to talk about, and then we'll hopefully have time for a couple questions at the end. But paragraph 2G here, buyer financial and personal information. So it is possible that you sit down with a buyer who says, I want you to represent me. I want you to help me buy a property. And I know I have to sign this agreement promising to pay you. However, I do not have the money. I have the exact amount of money I need for my down payment and potentially closing costs. And I don't have another cent to pay you. Or they might be getting a loan from a particular lender, loan product underwriter that doesn't allow the buyer to come out of pocket to pay buyer's commissions. That situation hopefully is going to evolve as lenders learn the reality of sort of how compensation is structured now, but that's still possible to have that scenario arise. So if that's the case, one, obviously a broker can say, I'm sorry, I can't work with you. Or you might say, that's okay, because, even if you can't afford to pay me, we can, use that offer and try to get the seller to pay my compensation. What paragraph 9B says, and we'll look at it in 1 second, is basically, if this box is checked, the buyer is authorizing the buyer's agent in every offer to use the RPA to ask for compensation to be paid. If the seller says, no, they're not paying compensation, well, there's two options. The buyer might say, okay, let's find another property. If the buyer says, no, I absolutely want to buy that property, but there's not going to be any compensation, buyer's agent does not have to work for free. That is the whole point, is we're trying to make sure everybody's protected and earning the compensation that they so rightly deserve. So what the buyer's agent could say is, if the buyer had disclosed up front that they don't have funds to pay and you agree to work with them anyway, it's basically creating a sort of contingency that says, okay, in the event that you find a property and we cannot negotiate with the seller to pay buyer side compensation, then I'm going to step back. And buyer, if you really want to buy it, you can go it alone. You can try to work some other arrangement out, but I can't afford to work for free. So we won't work together on that transaction. If you end up not buying that property, come back and talk to me and we'll start again. That's the idea. And finally, I kind of skipped over this, but it's worth mentioning. All buyers, so not just buyers who are having maybe strapped for funds, all buyers are being asked in the buyer representation agreement within 5 days from signing it to provide basically their financial and personal information so the buyer's agent knows what kind of funds the buyer is working with. So basically, what paragraph 9B says, and now's a good time to look at it, is, so within that time period, buyers will let the agent know, hey, here's the money I have. Here's what I have for down payment, for closing costs, and for paying my broker's compensation. So the buyer's agent knows that they are making sure they're entering into a relationship where they are going to be compensated no matter what. Again, even if the plan is to ultimately negotiate with the seller to have that compensation covered. The final note I want to make here is, again, this applies to all prospective buyers. We have a form BFPI, buyer financial and personal information, that can be used and that we recommend you use because it is consistent, and having all buyers provide you the same information is a good thing to do. Where people run into trouble, especially from a fair housing perspective, is if you treat different buyers differently. You can't have some buyers fill out that form, but not others. Some buyers provide you proof of funds, but not others. Make sure you have a consistent, policy of collecting the finance, or reviewing, I should say, your buyer's finances so that you know what sort of relationship you're entering into and what sort of properties they're going to be able to afford to buy and compensation they're going to be able to afford to pay. I know we're super short on time. Very, very, very quickly, let me mention one final agreement. We don't have to look into it because basically it's a shorter version of what we've been discussing. Oh my gosh, sorry. Bear with me for 1 second here. Okay. Property Showing and Representation Agreement, PSRA. This is essentially a mini version of the BRBC. What if you have a person who says, hey, I want to go look at this one property, or I want to go look at a couple properties this weekend. Can you show them to me? And you say, well, yes, let's talk about buyer representation. And they say, I don't want to commit to work with you for 3 months. I don't want to enter into sort of any extended relationship. I just want to see these properties. Then this is what that can be used for. It is a basically agreement that you're going to show them and ultimately represent them if they decide to make offers on those properties, up to 3 properties, and has a maximum period of 30 days. So it's basically like an introductory kind of arrangement where the buyer says, okay, you can work with, you'll show me these properties. I'll work with you on these. If it doesn't work out, everyone goes their separate ways. Maybe those properties don't work out, but your working relationship was great. And now you can sit down and say, well, let's sign a full buyer representation agreement and continue your house hunt together that way. But at least it gives you sort of an intro way to say, keep you compliant, let you, make sure you're getting this written agreement with the buyer, but not committing them beyond this narrow scope of whatever properties it's identified that they want to see. All right, and that is it. I know that was long. Thank you guys so much. I know we answered a bunch of questions in the middle, so hopefully that helped out, but I think we have 5 more minutes for questions.
Yeah, if we can bring in Corey and Alvena, come on in, help facilitate some of the Q&A. So we brought on a couple of our forms committee experts, Alvena and Corey. If you guys want to go ahead and kick off some of the Q&A here to wrap things up. I'll start with you, Corey.
First of all, I want to just, people, when you put questions in the chat, don't mention specific percentages or dollar amounts, please. I'm seeing a lot of questions about that. Just kind of say X, Y, Z, whatever you want. Jana, there was a lot of questions about new construction.
Oh, sure.
How do agents handle new construction and getting paid?
All right, I'm going to stop my share so we can all see each other. Yeah, so that's a really good question. And I'm going to be honest, it's not one that I have a super easy answer for, because I think a lot of it, so many things we're going to be waiting to see how certain markets and certain groups kind of react. But, I'll say there's no exception in the rules for new construction properties. They're residential properties. And so going to show a buyer a new construction property, you're going to want to have a buyer representation agreement with them. Now, I know that in the real world, how a lot of those situations are handled are sort of on a referral basis, where the new construction developer says, thanks for bringing the buyer to our property. We'll take it from here and we're going to pay you a referral fee. That could still be agreed to. It just literally would mean showing a representation agreement. And then if that's going to be the arrangement, you could agree to cancel that and then also make sure you are in fact getting whatever the referral agreement is with the new home developer and stepping out at that time. I don't know if there's going to be a simpler process that develops, but that's how I would see it working as of today.
Okay. All right. So speaking of referral agreements, and I apologize, I couldn't listen to you because we're answering so many
That's how it goes, yeah.
Referral fee from agent to agent.
Mm-hmm.
Can you just kind of address?
Oh, yes. Still fine. Yes. That's a great point to clarify. Getting a lot of questions on that. People hear that, people hear broker to broker compensation, that's going away. What we mean by that is the broker on one side of a transaction compensating the broker on the other side of the transaction. That's what the NAR settlement and lawsuits were really all about. Referral fees are typically all housed within one side of the transaction, right? So that's you saying, hey, I don't live in that area, but I have a trusted broker who does. I'm going to refer you. And that broker's going to say, thank you for your referral. I'm going to compensate you if I close this deal. But it's all for representing, the representation is all on one side. So we still have a referral fee agreement. That practice has not been impacted by any of these rule changes.
Okay. All right. And again, you may have answered this, but commercial transactions, investment transactions are all covered under the settlement, correct?
Well, so yes and no. So the terms of the settlement themselves do specify residential. So the settlement is basically tailored to and applicable to residential properties. That being said, two things. One is, as far as the MLS offers of compensation going away, my understanding is that field is just going to leave the MLS. It's not going to be picking and choosing type of listing. So that's one thing. Second thing is, I remember I mentioned buyer representation agreements are going to be required by law starting January 1st. That will apply to all types of transactions and licensees. So long story short, the settlement does say residential properties, but the way the changes are happening, I think commercial transactions, vacant land, all of that, people should get comfortable with what we're describing, because practically speaking, with MLS changes and then the upcoming legal changes, eventually it's going to apply to all properties.
Okay. Alvina, you go ahead for a few minutes. I'll look through my notes.
Okay, thanks. So we ended up having a lot of questions on something that isn't new, but I think we just had a lot of questions anyway. So regarding the RLA and the continuation time period. So when an agent gives that list to their seller, are they to include open house visitors? Are they going to include just the buyer's names or the broker names?
Great question. It's specific. So it is the list they can give is anybody who submitted an offer or physically entered and was shown the property during that period. That could include open house visitors. That, again, it's anyone who physically entered the property or submitted an offer or both. And I'm glad you hit on a key distinction. It's the individual buyer's name. So brokers' names don't do you any good. You can't just say the buyer who was brought in by Alvina. You have to be able to say this named principal buyer.
One quick answer is somebody heard you say either 90 days or 3 months. Can you correct what it is on the
Thank
BRBC?
you so much. That is a terrible habit that I need to get out of. 3 months, not 90 days. So apologize if I use those interchangeably. I've got to get better about that. It is 3 months is the maximum representation period. That's because that's how it's going to be defined in the law. So I know a lot of people have said, oh, but we use days in other parts of the contract. We do, but the law is set up so it's going to be 3 months. So the form is set up so it's going to be 3 months.
Perfect. And just a lot of variations of the same question. It's really about timeline, because I know it's odd. We have new forms, then MLS changes and new changes. So can you kind of give some clarity if somebody is in a contract right now and it's set to close after August 17th, what should they be doing?
Great question. Thank you for bringing this up. And there's really two possible situations. So one, maybe you are in escrow right now. You're in contract, you're in escrow, you're set to close. In that case, you don't necessarily have to make any changes. And I'll give a caveat in a second, but the offer of the compensation was made on the MLS. It was accepted and locked in when that offer was submitted and accepted. The property was shown before these rules ever happened. The parties can proceed and close basically under the structure as it exists today. That being said, maybe that deal doesn't close, right? Like that happens. That's not what we want to think about, but sometimes properties fall out of escrow. So I only mention that because you may want to go ahead and get your documents up to date, because if the property goes back on the market or the buyer goes out looking for another property, you are now going to have to follow the new rules. And so that brings me to my second point, which is, what if you just have an active listing right now, or you've started working with a buyer representative under the old BRBC form? Well, you do need to update those forms, because the prior version of the listing agreement and the prior version of the buyer rep agreement talk about things like cooperating compensation in the MLS, excess compensation, things that aren't allowed. So if you have a active listing or buyer rep agreement that's from before July 24th, you have two options. One, you could have your client sign the new form. You could take this as an opportunity to sit down with them and say, hey, changes here, let's talk about it. How about we sign this updated form? You could totally do that. But maybe you have a client who says, I don't want to sign a whole new form. We already did all of this. Well, then we have a form called the disclosure and modification to either the listing agreement or the buyer representation agreement, DM-LA or DM-BR, that you can use that will explain the changes to your client, and it will modify those forms so that they are now in compliance with the new rules.
Okay, one more thing so far. So a lot of variations of the same question. If a buyer's agent is working with a buyer, the buyer states they have no funds to pay the broker, which part of the BRBC would you recommend they refer to?
Right. So on that, when that situation happens, there's really two important things to do. One is to check the box in the grid, and I'm pulling it up because even I need to remember this. It's in 2G2. There's a checkbox where the parties agree upfront or acknowledge upfront that lack of funds. And then paragraph 9B is the section that explains what happens. Okay, so buyer who doesn't have funds to pay your own agent, we're going to be asking in every offer we make for the seller to pay me. And if they agree, we move forward. If they don't agree, buyer, now you have to decide if you want to move forward. I will step out of our representation because I can't work for free. And so you're going to have to decide what you want to do from there.
Awesome. Corey, do you have any updated questions?
Yeah. So, and you may have answered this already, but where do unrepresented buyers get the forms?
Great question. So like I did mention this, which is while C.A.R. has very strict rules, and there's also very significant risk management reasons why you cannot and would not just go and give blank forms to people to use. In this particular scenario, if you are representing a seller and the buyer says, I want to submit an offer, and you don't want them to just write it on a napkin or a piece of paper, right? It is possible for the buyer's agent to take a purchase agreement, fill out the identifying information, not leave it blank. So put in the parties' names, put in the property address, parcel number, all of that information, and then give that to the buyer and tell the buyer, okay, you can fill this out and return it to me to submit as your offer. Now, how will that work? If they're not familiar with the form, is it going to be sort of in great shape? Who knows? One thing that is also an option is, like, let's say that happens and the listing broker and the seller are like, this offer's a mess. Theoretically, the seller could then counter with their own purchase agreement and say, here's a counter offer, and my counter is C attached RPA. And then that way the listing broker is filling it out, but they're doing it from the seller side. You just don't want a scenario where the listing broker is filling out a form for the buyer. Again, you give the buyer non-agency, you explain you are not the buyer, or you're not the buyer's agent, but then you have to actually remind them of that and behave as such.
Yeah, and also give them the non-agency form.
Absolutely. Yeah, every step of the way.
Yeah.
I know I've heard that there are some buyers, they can contact a local association, see about forms being available. It's not something that's widely available, but it's something that you could have them look into. You could say you can contact your local association. Typically, though, you're probably going to be stuck navigating it by the listing broker.
Okay. And one last thing, can a seller refuse to work with an unrepresented buyer?
So a seller can basically decline offers for any non-discriminatory reason. What I would suggest, I get this question a lot, is, talk to your seller about, we have that section about compensation for unrepresented buyers. Talk to the seller about why that's there, how much extra work and potential for problems and risk an unrepresented buyer can be, but then leave it up to the seller. It's up to their discretion. And, the advice would be that they should consider all offers. You have to submit all offers that are accepted or that are presented, excuse me. But the seller absolutely, you can talk to them and say, well, here's problems I've had in the past, or here are issues that you may encounter dealing with an unrepresented buyer. And the seller can choose and say, well, then I'm not comfortable with a transaction that's set up like that. And as long as it's the seller's choice, that's okay for them to make.
That's pretty much for me, Alvina. Did we miss? There's probably 1,000 more questions.
There's 1,000 more questions. I think we're running low on time. So, Anthony, go ahead.
Perfect. Well, thank you, Jana. Thank you, Corey, Alvina. This has been a very helpful and timely topic. We appreciate all the information that you've presented today. Again, there is a lot of resources on the California Association of Realtors website. There's free courses that you can take. We've posted a lot of things, of course, in the chat box for you to grab and hopefully continue the educational process as we navigate these changes. The dominoes are already fallen. Things are starting to happen. And next week, and by the 17th of August, all of this is going to be in place. So thank you guys for being here today. And one more time, Jana, Corey, Alvina, thank you guys for joining us here on the webinar. And on behalf of the California Real Estate Brokers, Inc., we appreciate you all. And hopefully we'll see you on the next educational opportunity. Take care, everyone. Have a good day.